Well, good morning, everyone. Good morning, Pete. How are you doing?
Morning, Eleanor. I'm very well, thanks. And you?
See you. How's the lockdown technology treating you?
Well, not so well, as you know, so we should probably apologise for a slightly late start. We've
Yeah,
had a
I think we
few
should.
gremlins, but fingers crossed it should all be okay now.
Good. Well, yes, that's an indirect apology from me as well for the late start, but yeah, I'll get going now. So many thanks to all of those who joined us on this webinar. Hopefully you probably know who we are already. I'm Eleanor Gray, and I'm joined by my colleague who will introduce himself in a second, Pete. I suspect that many of you will know that I certainly spend a certain amount of time representing both the Professional Standards Agency and the General Medical Council. And we're obviously going to talk this morning about a decision about the General Medical Council. Our colleague Alexis Herndon appeared for the GMC, but these are very much in this discussion the views of Pete, the views of myself. They're not any official views on behalf of any of the bodies that were involved in this appeal. Pete, sorry, do you want to add anything to that?
No, I mean, I think obviously just to introduce myself for those that don't know me, I'm Peter Mant. I think that's right. We will be expressing some views. Of course, the other thing to add is that nothing we're saying is formal legal advice. It's going to be very much more in the form of a discussion and throwing around different ideas, because I think this is a really interesting judgment that does raise quite a few talking points.
Yeah, so the usual disclaimer about us not giving legal advice. The other disclaimer or point we have to bring to your attention is that we are recording this webinar. We put them up on our website for people to view afterwards. So what we'll do in terms of questions and answers is that if you want to submit any of them through the facility you've got to pose questions on your screens, we'll try and take questions or comments as we go along, at least if we think we can answer them, because that's probably a bit more interesting than leaving everything until the end. If you do post a question or make a comment, we'll introduce it, but we won't mention your name. So please don't be offended if we just say a person has commented. That's because if we're recording this, we don't want to identify anybody, but apologies to all of those whom we do know and value if we don't identify you by name, if you contribute to this as well. Okay, what we wanted to do just by way of introduction, although this is a discussion between the two of us and yourselves as you join in, is we thought we would just set the scene a little bit about this case by going through a few slides just to sort of remind those of you who haven't read it recently what was decided by Mr. Justice Warby. We're aiming, I think, to have a discussion that lasts for about 45 minutes or thereabouts. We thought an hour might be a bit excessive, but obviously we'll see how it goes and what interest we spark as we go along. So I'm going to hand over to Pete to start the slides off, just to sort of orientate ourselves before we talk in a little bit more detail.
Sure. Yeah. So first slide we've got up. What is this all about? And it's a case, a practice case against a cosmetic surgeon, and there were a series of different allegations. So relating to a period from 2009 to 2015, there were the allegations in relation to patient A, which related first to the operation, the breast augmentation operation in 2009, and the allegations included failure to obtain informed consent. And what was a particular focus of this appeal was an allegation that the patient had been offered a financial incentive to undertake the operation quickly. So the patient's case was that the surgeon had said, if you undertake this operation in the next week, I'll give you a £600 discount. And that was alleged to be as improper pressure on the patient to make this important decision very quickly. There were then also allegations, I should say then there was an allegation in 2010. So following the concerns about the operation in 2009, which were referred to in the judgment as the 2009 allegations, you then have in 2010, there is a scan of the breast to see whether there are any problems. And there's an allegation that the surgeon failed to report or said that there was nothing wrong on the scan, when in fact there were concerns that arose. You then have these separate allegations again in respect of the treatment of patients C, D, and E, and the thrust of those related to failure to obtain proper informed consent. There was also issues of inadequate record keeping. Then what's it all about procedural steps? Eleanor, were you going to take them through this, or shall I?
Sure.
I don't really
I
mind.
guess we can take it in turn. Probably makes it mildly more interesting if one of us talks a little less often. So the Dr. Dutta himself first came to the attention of the GMC in 2014, but it was very much in the context of an investigation into a different surgeon. And the police notified the GMC really mostly about those concerns. But in the sort of midst of that, there were some remarks by patient A which related to Dr. Dutta. However, the important thing is that the GMC didn't actually open an investigation at that point. So they didn't really take those comments as amounting to a suggestion that Dr. Dutta was unfit to practice in 2014. What sparked action was referral by the CQC in 2015, which led to an investigation being opened and a statement being taken by patient A. So there was patient A with a statement relating to those events in 2010, and also we haven't really majored on this because it had less centrality in the appeal, some further events in 2014. There was also at that point then, with the fuller investigation, the addition of the charges relating, or the matters relating to patients C, D, and E. So all of that led to a decision in 2016 that the matter would be referred to case examiners, and relevantly for the purposes of this appeal, a decision by the assistant registrar, having taken legal advice, that Rule 4.5, that's the 5-year rule that many of you will know, we'll come back to that at the end, wasn't engaged. So it was said that the relevant events had come to the GMC within the last 5 years. So treating the events of 2009 as one course of treatment and as being within 5 years of that police conversation. So in 2016, Dr. Dutta was informed that an investigation was open and the usual processes started to grind along. But he wasn't specifically told that there had been a decision that Rule 4.5 wasn't engaged. That as a specific decision didn't emerge until very shortly before the fitness to practice hearing in, I should go back for a second, yes, thanks, yes. Pete. When in early September 2019, his lawyers began to ask questions about this, and he was explicitly told of the Rule 4.5 decision. And then, as you can see, about 6 weeks later, the MPTS hearing started, leading eventually to a series of findings against him and a 9-month suspension, against which he appealed. So Pete, if you take the next slide, perhaps.
Yeah, absolutely. And perhaps just one thing to add on that timing, which I think may be significant, is that the solicitors made that initial inquiry on 12th of September, but I think they didn't actually get the document of the Rule 4.5 a few days before the hearing. And then there was the question, which I think will really sort of leads nicely into the next slide, about whether they should have brought any judicial review challenge at that stage. And they elected instead to go ahead with the hearing and brought a challenge afterwards. So there's two elements to the challenge. there's a judicial review of the 4-5 decision, which is obviously many years after the decision was made. And there's also a Section 40 appeal, which focused on the findings of fact that were made. But of course, in the ordinary course of things, if you are challenging findings of fact which are fundamental to the misconduct and impairment stages, then those, if you like, are indirectly challenged or fall away if you succeed on the facts. So in terms of what was held, it is perhaps interesting to note the order in which the judge took it, because he took the appeal first and then the judicial review. And if we've got time, we might just discuss the significance of that. But for now, I think the important things to note are that in relation to what we've described as the discount charge, so the allegation that the doctor acted improperly in offering a financial incentive to the patient to undertake the surgery within a week of the initial consultation. The court found that the factual findings that was proved were procedurally flawed and untenable. Now, we're going to look into the reasoning in a bit more depth, but just to sort of flag the key aspects of that finding here. The court found, in relation to the procedural flaw, that what the tribunal had done had been to make a decision on an entirely different case theory. So the patient, very broadly, says, yes, I turned up for this consultation and I was offered this surgery within a week if I had a discount. There was then a pre-op appointment. Again, this is not disputed, on the 2nd of April. And the appointment ended up, the surgery ended up being deferred until the 11th of April. So on the patient's own account, this offer has to have been made in late March. The doctor says none of that can have happened, because when you look at the records, there was a consultation at the beginning of March, and we have email evidence that at around 4 o'clock, so I think the consultation was at something like 1:30, and at 4 o'clock, there's email evidence of the consulting room being booked for the 11th of April. So you have these diametrically opposed accounts, and what the tribunal does is sort of finds this middle ground and say, oh, well, essentially what we think must have happened is that at some point between that consultation at, I think it was around 1 o'clock, and that email confirming that the theatres have been booked, that something must have happened to mean that the slot that was previously available wasn't available. Now, no one had suggested that. It wasn't put to the witnesses in evidence. And that's the procedural flaw, which again we'll talk about in more detail, but is if a tribunal is going to come up with an entirely new sort of theory, when does procedural fairness require that is squarely put to the relevant parties? You then have the untenable, and broadly what the court says there is, looking at the evidence that the tribunal did here, it simply was not open. Even
Pete,
allowing...
I'm just going to interrupt you just for a second, if I may, because I'm just looking at the questions and answers that are coming in.
Yeah.
A couple of things. One is that I just hold the point that you were on, the untenable point. Yeah. Forgive me for interrupting. But one is that you're breaking up quite a lot. And since you're just about to carry on with an important point, I just wondered whether you had any headphones to hand. There was nothing like introducing a technological glitch in
Sure.
mid-webinar, but it's just a thought if you do have anything that might solve that problem. While you're doing that, I'll just pick up the second point that was made by somebody, or the question that was being asked, which somebody asked whether this course or this webinar has any relevance to care proceedings. And so I just thought I would say that we're not specifically talking about care proceedings, and there is quite a bit about this in this second half of this discussion about some GMC issues under Rule 4.5, which we've mentioned already. But what we are talking about, and what Pete's just been starting to introduce, is the whole question of how do you challenge findings of fact made by a tribunal? Now, that tribunal could be a tribunal like the Medical Practitioners Tribunal. It could be a tribunal within the court system like the Care Standards Tribunal or the Social Entitlement Chamber. It could be a High Court tribunal, a High Court series of findings of fact. It's all about what do you do on appeal if you don't like the findings of fact made by a tribunal. So I'm not sure that the context from that point of view matters very much. We're obviously talking about disciplinary proceedings, but any factual findings, including potentially care proceedings, could be caught by what we're talking about. Pete, do you agree with that? Am I being
Yeah,
too
no, absolutely.
generous?
And I guess it's not just appeals, actually, is it? Because we'll be talking about first instance as well, and how courts and tribunals should be making their decisions at first instance. So I think part of what we'll talk about is, once they've made that decision, what scope is there for challenging that finding on appeal? But I think the bit that I'm particularly interested in is this question of documents and demeanour that we'll be coming on to. And in fact, I'm afraid I don't have headphones. What I'm going to do, just come a bit nearer my computer. It's usually not a problem, but this is the less sophisticated solution to the problem. And I was just we talked about procedural flaw, and I think it addressed that. And then there's this question of untenable. Just to flag and outline at this stage, what the court says is, on the evidence that was available, the conclusion that the tribunal drew was one that was not properly open to it. And the basis for that was in large part, and we're going to come on to this in more detail, that the tribunal had relied very heavily on the patient's demeanour and effectively made a finding based on the patient's demeanour, and then said, and is there anything in the documents which means that this is not possible? And they said the documents are not determinative of a different conclusion, and therefore we go with our gut feeling that we believe the that we believe the patient. And the court says that that is not the correct approach.
Yeah. So, I mean, if I can just broaden that out again, and again, in relation to some of the questions that are coming in, what we're talking about is good decision making, really, and how to make findings of fact in a way that is fair, and then of course won't be susceptible to challenge on appeal. And I think that just sort of reiterates the point I was trying to make earlier, which is that potentially it is of broad relevance across all areas of litigation, because it's about how do judges go about judging the veracity or otherwise of the accounts that are presented to them. And in particular, and this is the point that Pete's just been making, what weight can you give to a person's demeanour, how they give evidence, the confidence with which they make their assertions, the manner in which they stare the judge in the face? What weight should a judge be putting, or judge or a tribunal or any other judicial decision maker be putting on these sorts of issues? So Pete, sorry, I'm very good at interrupting you. Do carry on.
Yeah, no, it's interesting, and I'd be interested in your view on this, but I think probably some of these principles are relevant to sort of quasi-judicial decisions, or even factual decisions by a public body, in the sense that it's, say, if a social worker is doing an age assessment. Now, it's a bit different because they have more time and more experience to work with someone, but still, I think some of the comments about where there may be cultural differences in particular, how much weight can you give to your subjective assessment of do I believe them or not, relative to the more objective evidence of documents and consistency, I think probably does have a very broad relevance.
Yeah. We should move on, because I've spent so much time telling you what we're going to say that we won't get round to saying it. Pete?
Absolutely. So we can very briefly now, I think we can say that there were other factual findings which were upheld, and then we have the judicial review. And in relation to the judicial review, significantly, the court allows an extension of time on the basis that the patient was not actually informed expressly of the Rule 4.5 decision, and he wasn't legally represented at the time, and then finds that the registrar was wrong to say that that Rule 4.5 was not engaged, because the 2010 scan was a separate allegation to the 2009 incidents. And also he found really an error of law at both ends. So there's the error of law at the end of where is the allegation. And then also when it first comes to the attention of the GMC, to use the wording of the rule, they say, well, actually, it didn't, the allegation as such, as opposed to some generalised concerns, did not come to the attention of the GMC when there was that initial conversation with the police that related primarily to a different doctor. So those are the findings. And I think now we're tantalising questions and contributions, and this is where Eleanor and I are going to sort of explore the wider issues. And I'm actually going to take this slide down now.
What an excellent idea. I was just about to say, why don't you put up instead paragraph 21 of the decision, rather than having us, you know, taking over the whole screen, because that really introduces the sort of first theme that we wanted to talk about, which is the way in which the judge went about summarizing the principles about when you can challenge findings of fact by a tribunal. He went through, or was invited, of course, to look at a whole series of cases about challenging findings of fact, and the sort of the sort of summary position, which I fear those acting for respondents do sometimes trot out as if it was the only thing to be said, is the observation of Mr. Justice Leveson in Southall, that this is paragraph 22, Pete, but I'm going to go back to paragraph 21, where he says it's very well established that findings of primary fact, particularly if founded upon an assessment of the credibility of witnesses, are virtually unassailable. And so we sort of tend to start, if we're acting for a respondent, with this proposition that if there are findings of fact by a tribunal, particularly if based on credibility, they will be virtually unassailable on appeal. But Mr. Justice Warby went into it in some considerable detail, and this is where we probably need to scroll back to paragraph 21, and gave, I think, rather more emphasis to other principles that sit around and perhaps rather qualify the statement by Mr. Justice Leveson. I mean, the first point he's making at paragraph sub 21.1 is that this is the appeal in this case was a rehearing rather than a review. And he points out that what that actually means is not always entirely straightforward to understand. He says it's an elastic notion, but generally more intensive than a review, and that the test is not the Wensbury test. And I'm sure the lawyers listening, although it's not obvious, will know that Wensbury means that the test is that to establish that something is wrong, you have to establish that the tribunal has reached a decision which is so unreasonable that no reasonable tribunal could have reached it, or it's perverse. So he says it's not that, but I have to say, Peter, and I'd be interested in your views, I'm always left struggling to know what it actually is if it isn't that. Because
absolutely, I think, sorry Eleanor, I think I cut across you there.
Well, I was just going to say that if it's not elastic, I personally think it's elusive.
Well, it's funny, that's exactly, I was going to quote you and use that rather nice turn of phrase of elusive rather than elastic. And I think we see that in particular, if we just scroll down, now the court has placed particular reliance on the case of Casey, which is a Northern Irish case, and I think isn't one that you tend to see sort of cited in a lot of the other more recent authorities compared to Southall, which is trotted out repeatedly, including by the divisional court recently in Jagjavan. But if we look here down at point 7, the judge says another way of putting the matter is that the appeal court may interfere if the finding of fact is so out of tune with the evidence properly read as to be unreasonable. And when I read that, unreasonable in public law has a particular meaning, which is synonymous with Wednesbury unreasonableness.
And if I can cut across you, Pete, the interesting thing is that if you're citing Southall at 47, when Mary O'Rourke was addressing Lord Justice Leveson at that point in her submissions, she was attacking the findings of fact and saying that they were perverse. Mm-hmm. And it was a test of perversity that was being considered by the court, which again, in a sort of Wednesbury terms, is regarded as being synonymous with the Wednesbury test. So unreasonable, Wednesbury unreasonable, perversity, they're all pretty synonymous phrases, and they are establishing a very, very high test. So quite what so out of tune with the evidence properly read as to be unreasonable means, if it isn't Wednesbury, is not straightforward, is it? And I think you were going to make a comment on where that comes from in relation to the source.
Yeah, so what's interesting is I think Mr. Justice Warby was sort of suggesting at a lower threshold and suggesting that perhaps the way that we've often trotted out Southall is not right. And he says, if we look down further on paragraph 22, that actually when you read Southall as a whole, this sentence about virtually unassailable does not purport to present a distinct principle. And then he says that Southall at 47 shows that the passage I've quoted from Casey reflects high authority. But I thought it might be interesting if we just go to Southall briefly, and this is the key paragraph here. I've highlighted a couple of points. So at the top there is highlighting the bit that does tend to be repeated about virtually unassailable. And then you can see a number of other authorities are paraphrased. But the bit from Libman, which is taken out there, Lord Hailsham, is in these terms, can be shown, so the facts can only be reversed if it can be shown that the findings were sufficiently out of tune with the evidence. So we have that bit, but then to indicate with reasonable certainty that the evidence has been misread. And Mr. Justice Warby in Dutta is effectively saying, oh, well, the formulation in Casey is just another way of saying this. But what's missed out, and if we go back now to that Casey formulation, the Casey formulation of so out of tune with the evidence properly read as to be unreasonable, is you lose that bit of reasonable certainty. And I'd always taken that reasonable certainty to be a really quite high threshold.
Yes, if you stop sharing your screen, Pete, I also went back to Libman. Let's just see if I can find where I had it. Let's just see, let's share mine for a moment. These are the words of Lord Hailsham again, or part of them from Libman. And I'd highlighted firstly, that at subparagraph 2 of this bit, he talks about there being a heavy burden on an appellant who wishes to displace a verdict. And that emphasis on the heavy burden is something that does run through the authorities. And I think it's acknowledged, to be fair, by Mr. Justice Warby, but I think you can see it given greater weight in other authorities. And then here we've got another formulation of this test. It follows that the only circumstances in which an appellate court can reverse a view of the facts taken by the disciplinary committee would be a case where on examination it would appear that the committee had misread the evidence to such an extent that they were not entitled to make a finding on the state or in the state of the evidence presented before them. And that seems to me, again, I would struggle to put a cigarette paper, if I'm allowed to refer to cigarettes on webinars these days, between that formulation and a Wednesbury test, because it really does approach a perversity test, I would have thought, but there we go.
And maybe this is perhaps a slightly broader point, but I've always found that Wednesbury itself is quite elastic anyway, and that depending on the type of decision you're challenging and a judge's instinct as to the merits, what's unreasonable or not can take very different characteristics, I think.
Oh, I really couldn't agree more than that. I mean, you know, we go back to that old thing that in the law, context is everything. And just as I think we are seeing here that what Mr. Justice Warby is doing is taking very well acknowledged and undoubtedly correct authorities and putting them together in a way that does perhaps give slightly greater weight to the scope for challenge than you may see in another case where a judge has formed the view that the findings of fact are unassailable. Equally well, I think inevitably what he's done here has taken colour from and is a precursor to his approach to the facts. And there, as we'll see, I mean, my own view is that there were very good grounds to challenge the way in which this tribunal approached the primary issue of the credibility of the witness. And there were errors of approach, I would agree, with the way in which they put their decision making together. And so you can then see how that slots into his interpretation of or his use, perhaps we should say, of the authorities that are before him. But I suppose the sort of takeout point is from this that there is scope to subject the virtually unassailable test to quite close analysis. And if you do that, you see that there is a hinterland behind it and a series of authorities that give you greater direction towards how you could go about undermining the credibility of a witness. And I do almost think that it does lead to something of a qualification of the virtually unassailable test, because if we have that up again, if we say that it's very well established that findings of primary fact, particularly if, do we need to say now, if reasonably founded upon an assessment of the credibility of witnesses, are virtually unassailable? Because you can challenge an assessment of the credibility of a witness if it hasn't been made in a reasonable fashion. And again, absolutely. I'm giving reasonable that Wednesbury weight, I think.
I think that we should perhaps come on to that then in terms of what it was
not least
that
looking
was
at the time.
unreasonable. Now, I've seen one quick question, which was, how does this apply to findings of secondary fact? Because that's something we could perhaps just touch on briefly. A primary fact in broad terms is just, you know, really straightforward, what happened. And then the secondary fact, I think, is really getting at inferences. For example, sexual motivation. That's not something that you can, very often at least, find from just simply what someone did, but it's about taking the context of what they did, what they said, and other factual background to infer something. Now, the civil procedure rules make clear that on an appeal court can draw its own inferences. And I think Casey was actually a case about inferences as well. So I think what I would say, and Eleanor, chip in if you disagree, is that it's always been easier to challenge findings of inferences than findings of primary fact, because they're not in quite the same way based only on credibility. And so I think that some of these broad observations probably are of general application, and that overall, where there is an inference, the court will be, I think, slightly more ready to interfere.
Yes, I think that's right. It's the primary facts where traditionally the appellate courts have been reluctant to tread, because they are very accustomed to saying that the first decision maker has got the advantage of hearing from the witnesses directly, and you don't get that flavour if all you're doing is looking at transcripts. If you're looking at inferences, it's always been something that has been a little easier to challenge, albeit that you are still always dealing with the deference to the specialist tribunal point, aren't you? And deference is quite a complicated concept. It isn't simply about technical matters. It's about the sort of nuances and feel for an area that would also, I think, make an appellate court hesitate.
Mr. Justice Warby, in this case, looks at it and says that he had cited to him a lot of authorities about deference to specialist judgment into the misconduct and things, and he didn't consider them relevant to this particular case. But he makes the point very clearly: there will be circumstances in which a specialist tribunal has specialist knowledge relevant to fact finding, and I think that's going to be particularly the case, say, in relation to more clinical allegations, because the particular factual challenge where he was saying it's not relevant was this factual challenge about was a discount offered. And you can see that's a pretty pure sort of thing, which doesn't require any clinical understanding, or at least arguably doesn't. I guess you could take it the other way and say that understanding of how these things work generally is somehow relevant. But should we go?
Move on. We should move on.
Absolutely.
To the whole question of demeanour.
Then at the court's approach to this issue of credibility and findings of fact, we can see here at paragraph 39. So I've already explained in broad terms what the tribunal did, which was said based on demeanour, I believe the patient, and there's nothing in the documents which means that the patient's case necessarily or determinatively couldn't have happened, and therefore we find those facts proved. And Mr. Justice Warby goes through some of the case law relevant to demeanour, and cites in particular a recent decision of, or relatively recent decision of Mr. Justice Stewart in Kimavi. Now, I'm just going to highlight a few of the bits here, which I think are particularly interesting. And this is the summary of Mr. Justice Stewart, where he's summarising other authorities here, Jestmin. And you'll see the first bullet point there, that we believe memories to be more faithful than they are. And there are two common errors. One, that the stronger and more vivid the recollection, the more likely it is to be accurate. And the second, that the more confident another person is in their recollection, the more likely it is to be accurate. The point is made there that memories are fluid and malleable. And I think this is really interesting. There's scientific evidence on this, as well as just sort of judicial anecdote.
Yeah, it's based on sort of psychological learning, isn't it?
Exactly. Each time we remember something, we are actually sort of reformulating it in our brain. And I think that that's now a sort of uncontroversial, that is, as a matter of fact, what happens. So over time, your memory of an event evolves, and something can appear very vivid and yet not in fact be a true representation of what happened. And I think that's the third bullet point, really, isn't it? That events can come to be recalled as memories which did not happen at all, or which happened to somebody else. Absolutely fascinating. I think the idea that something could have happened to someone else. And I think in a family context, I have memories from childhood holidays, and then I look at a photograph that's in a photo album, and I'm thinking, am I remembering and projecting on the basis of that photograph, or do I actually have any independent memory? And I'm sure everyone has the family anecdotes and that kind of thing, where you're not actually sure, are you just remembering what everyone shares at Christmas, or do you genuinely have a memory of it? Which I hope doesn't trivialize it, but I think does put it in some kind of context. Yeah. And then we have this formulation of the best approach, that the best approach from a judge is to base factual findings on inferences drawn from documentary evidence and known or probable facts. That this does not mean that oral testimony serves no useful purpose, but its value lies largely in the opportunity which cross-examination affords to subject the documentary record to critical scrutiny. So that really is relegating, in terms of the hierarchy of evidence that you rely on, this oral evidence to something quite low down. And then finally, above all, it's important to avoid the fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. Because I think you often get this slightly crass submission made by always by opposing counsel, never by me, of course, but where, you know, it's a cheap point, and you say, well, you can only find against my client if you find they're a complete liar, and obviously they're an upstanding person. And it, you know, it might have worked in Slough County Court in a small claim RTA, but I obviously no discourtesy to the judge hearing that case, but I certainly think most judges are pretty alive to that fallacy now.
Well, it's a difficult one, isn't it? Because you know, what we're being told to do here is to, first of all, to look at everything in the round, and we'll come back to that in a moment, I'm sure, but to look at the documentary record and known or probable facts. Now, if you don't have a documentary record, and there was one in this case, which is important. I mean, it really was the email record of when the procedure that was actually booked that was determinative in the judge's mind. But if you don't have a documentary record, then how many times have you found yourself making the submission, or perhaps have you heard opposing counsel making the submission that my client gave evidence in a clear and compelling way? She was, you know, not swayed in what she had to say. She remembered things vividly. And yet we're being told, on the basis of really very, very good psychological evidence and study, that that is not a reliable way of judging the truth of events. Not straightforward, because you're rather left sometimes thinking, well, what have we got? In some cases, anyway.
I mean, actually, and perhaps it's interesting going back to the sort of road traffic accident, you know, which is in some ways can be the sort of paradigm simple civil case, if you like. I'm talking about a sort of relatively straightforward one without reconstruction evidence and all that kind of thing. You do just have one person saying, you know, he pulled out first, and the other one saying he didn't, and sometimes,
and which is the most probable version of events to test that against, I don't know. Yeah, but I think that, you know, it's going back a little bit from the this is all very difficult, so what do we do stuff. The interesting thing I think is that, as Mr. Justice Warby points out, these cases and this distillation of psychological evidence is part of the armory of judges in their accrued knowledge and the basis on which they know they ought to approach decision making. I think it is, well, I could say it is part of judicial training now to be exposed to this psychological evidence and to know about the fallacies of decision making based upon demeanor alone. And that's, of course, partly it's also linked, isn't it, to the whole question of cultural biases and the way in which different people, different backgrounds will approach giving evidence in different ways. So there's quite a lot of judicial training on this. Now, I don't purport to know anything about MPTS training, but it's obvious that this sort of learning has to be part of the armory of any form of judicial decision maker, whether in the tribunal or courts or whatever, or else they'll be susceptible to this sort of attack in appeals, I think.
Yeah, no, absolutely. I think that perhaps, so I know we've got lots of people from a range of different regulators among the people listening, and maybe one of the take-homes, if you like, to think about what training that the panels currently get and whether there is scope for more of a focus on this learning.
So I'm just sort of conscious of the time again. I'm going to ask you, Pete, do you think that there is a danger that this privileges the documentary record? I mean, specifically in the GMC context, you know, the documentary record that is most obviously available can be the medical records. And they may not have been seen by a patient. Some practices, the practice varies, but in many practices, they won't be seen by the patient until they've made a complaint or even afterwards.
I think it is very difficult. And, you know, I asked the question sort of rhetorically, what do you do about the really bad apples? So the ones that have fabricated records or have simply produced very poor records. if the court is putting such a strong emphasis on that documentary account. I think there are some answers, and if we go a bit further down, we can see, so there Mr. Justice Warby saying about, instead of starting with the objective facts, they took it the wrong way round. So further down the bit that I wanted to look at, just here, that the flaws are all the more significant given the antiquity of the events in dispute, which were 10 years old at the time of the hearing. The older the events, the more important it is to hold fast to these principles of reasoning. And I think there we see a bit of a chink for how you can perhaps distinguish, on the one hand, very historic events where the only documentary record is the medical record and associated emails, with something that perhaps happens more contemporaneously. The complaint is made. There might then be a written document of the complaint. There might even be things like a text message you see sometimes from a patient to a partner, saying, I felt very uncomfortable with the doctor because the doctor did X or Y. So I don't think that it needs to be something which privileges specifically the medical record above other records. But I do think, and I'm not sure it's wrong, I do think if you are looking at something that's happened a long time ago, and the only record is the medical record, it may be inevitable that you have to place very significant weight on that, unless there are, for example, internal inconsistencies.
I think that for my part, I would say, whilst I agree with everything you've said, Pete, that there is also something to be gained from other tribunals learning on this, because the one area that I'm fairly familiar with is the social entitlement chamber, and then the decisions of the upper tribunal in appeals against that tribunal, the administrative appeals chamber. And in that, you quite commonly have the problem of a patient or a service user saying, I suffer from X, and these are the symptoms it gives rise to, this is my disability, and this is my lived experience. And then that will be accompanied by sometimes the GP records or a medical assessment from the likes of Atos, which can be hugely controversial. And it's quite clearly established there that if you were simply to say, well, the patient's evidence is not consistent with what the medical record says, therefore I reject it, that would be an error of law. And it goes back to the point that what you're trying to do is you're trying to assess everything in the round, and you're using all the sources of evidence to try and build up a picture of what are, first of all, the accepted facts, then the sort of known and probable facts, and then you almost infer from that where the truth of the disputed facts lies. So in this case, the primary error was saying, well, I believe the patient because her demeanor was compelling, effectively, and then I'll put in the documentary record and I will say, well, that doesn't require me to change my mind. The opposite error that you can sometimes see in the social entitlement chamber is to say, well, I've seen the documentary records and they tell me X, and therefore I must reject the patient's evidence. And what you actually have to do is to try and put them all together, and from a process of reasoning from the accepted, the uncontroversial, the probable, arrive at a sort of rounded construction of what the most likely version of events is. And if you can try and do that, then I think you're probably going to be less susceptible to some sort of review process. And interestingly, of course, the upper tribunal, when it knocks back these decisions on this basis, is finding an error of law. But it is doing so in quite a subtle way, using all the material at its disposal, and which I think, ultimately is what Mr. Justice Warby was saying the tribunal failed to do in this case. I think we probably need to move on a little bit, don't we? Because the only thing I would say, we move on, but then I also say there's a very interesting question that's just been raised on this point, where someone has asked us, how might the approach of the appeal court to findings of the court below based on a witness's demeanour change in the world of hearings being conducted remotely?
That's a very
Well,
good question.
that's a very good question, isn't it?
I mean, I think my instinct would be that even less weight can be placed on demeanour if you're hearing someone via Skype. I had a case yesterday where the technology failed and we ended up having someone cross-examined just by telephone because their video link didn't work. And interestingly, the judge in that case really placed very little weight on any issues of demeanour or the way, in fact, no weight on the way the evidence was given, and very much made a decision based on contemporaneous documents.
Yeah, I mean, that would be inevitable in those circumstances. The question is whether it would be any less fair. Interesting, I mean, I was doing a hearing yesterday in the mental health tribunal, and there we were looking at a situation where it was quite possible that we wouldn't be able to hear from the patient by video, and we would only be able to hear him by telephone. And, you know, in that situation, the solicitor protested that that would be unfair and we needed to see the patient. And, you know, we resolved it. We were able to see the patient. But it does demonstrate, doesn't it, that we do like to see the people that we're making decisions about. And perhaps we'll continue to put some weight on that, at least as part of the whole.
With your sort of judicial hat on, Eleanor, how did you feel about the idea of not seeing the patient? Just in sort of instinctively,
instinctively uncomfortable. I mean, you know, you're making a decision about someone who is very heavily affected by what you're going to do. I think cuts both ways. I mean, part of the submission that the solicitor was saying was that he ought to see the people who were making the decision about him.
Yeah.
So that's a rather different point, but
it's
I think we all
being
find
seen to be done as well as justice being done, I guess, isn't it?
Fact finding by telephone is an uncomfortable thought. However, I mean, I don't think we've answered that question. I think it's something that will run and run, to be honest, and I suspect that experience of learning will build up if we're forced into this world. But I think looking at the time, we've certainly passed our goodness me. We'll see whether our attendees start dropping off.
Yeah, that'll be a cue to stop, I think.
In the meantime, let's move on, because one of the other reasons why this decision was quashed, and I think we can take this point a bit more briskly, was procedural fairness. I mean, just to sort of introduce the point, or to reiterate it for those who heard what Pete was saying earlier, part of the problem in this case was that when the tribunal said, we don't think that the documents preclude us accepting patient A's account, we think that something might have happened between the doctor offering patient A a discount based on an immediate immediate operation at sort of 12 or late morning, and the booking email that went in later that afternoon, which clearly booked it for 6 weeks later. So something might have happened, the tribunal said, or we can't preclude the possibility that something happened to change the date of the examination. And what the judge said was that, look, if you're going to make your finding on that hypothesis, you have to have put that to the parties. It wasn't part of anybody's case, and it's possible that there might even have been further documentary evidence about it. And, you know, Peter, I don't know what you think about that, but
I think that on the facts of this particular case, that's probably fairly uncontroversial. It strikes me that there can be quite a spectrum of possibilities here, though, because it's not uncommon for one party to say A, one party to say B, and the judge to say something in between. And so I think that in itself wouldn't always require sort of the parties to be very expressly put on notice if it all sort of falls within the same matrix of what is being discussed. I think the point is here that it really was an entirely new case theory, I think is the way the judge puts it. And the judge also makes the powerful point that there could well have been evidence. So if the case was put on the basis, no, we say that we think that there was the possibility of an early appointment at 1:30, but that transpired not to be the case by 354, then the doctor could have gone off and, for example, made inquiries with the clinic, scrutinised his own records, and there might have been something to disprove that, or conversely, I guess, to prove it.
So again, context is everything, really. It's a sort of spectrum of possibilities, but I think it is something that a tribunal has to be quite aware of. They have to be aware of it when they're sort of formulating new case theories. They also, I think, have to be aware of it if they, there's some law sometimes where if you do pick up something particular from a witness's demeanour or from something they say, you need to be sometimes quite alert that that point is put to the witness. But it is a context thing. Let's move on, shall we, to Rule 4.5, unless there was anything you wanted to say further on demeanour and procedural
No, I
fairness.
think that would probably be a good time now to move on. And I think there are really two issues which, again, we should probably take fairly briefly arising from the Rule 4.5 decision. There's firstly the point about an extension of time. So they extended time by really more than several years. And the GMC's case, which I have to say I have some sympathy with, is that it was effectively obvious and implicit in the fact that so the doctor was informed when the matter was referred to the case examiners. He was
in
told
2016, basically.
Yeah,
in 2016, and that's where time started to run.
So 4 years. And you have at that stage in 2016, the doctor's told all these allegations are going to case examiners, and it seems to me that it was implicit in that the 5-year rule had not been applied. For my part, I think had the doctor been legally represented at that point, there probably would have been very little doubt that any competent regulatory solicitor acting for a doctor would have known that that meant Rule 4.5, the 5-year rule, had not applied. But the judge seems to place particular evidence,
particular weight,
on apologies, I just think I got this slightly wrong.
No, I'm not sure you did actually, or you certainly pointed to a passage that I wanted to.
There you go. Yes. So the first point, placing too heavy onus on the subject of an undisclosed decision to work out that it's been made and why. The evidence clearly showed that Dr. Dutta did not have actual knowledge. So it's focusing on actual knowledge that the decision had been made, and that in 2016 he did not have legal advice.
I think there's a lot of weight riding on that fact, isn't there? We've just spoken about.
Yeah, absolutely. And I certainly think another judge could have said, well, yes, you weren't legally represented, you could have sought legal advice, you could have simply looked at the rules, and it would have been apparent to you that they were allowing an old allegation to go forward.
And then it goes on, when he did obtain expert advice, his lawyers were unable to identify, sorry, Pete, you don't need to scroll on, just sticking with where we were, the true nature of the AR's decision. Well, I mean, that's, I think, unless there's something I'm missing, simply a reference to the fact that at that point, the lawyers did say, can you explain what happened? And let us have a copy of the determination, to which inevitably, and as you would expect, the GMC then replied. So anyway, sorry.
I agree. It seems like, to me, the way that the reasoning is framed, so that there's a lack of detail as to why not having legal advice was sufficient. And then further down, this is paragraph 78, the criticism of what's described as the GMC's lack of candour. Now, the fitness to practice rules as currently drafted don't require that Rule 4.5 decision to be sent to a doctor, so it's not part of their sort of current policies and procedures. But I think it's interesting that the judge is saying here in really quite strong terms that it should be. and that he was unclear of what good practical or policy reason there would be for reticence. So I think you do have quite a strong message, really, which goes beyond the specifics of a Rule 4.5 decision to the GMC, but to public bodies where you are making particular decisions, applying a particular legal framework, that generally those should be ones that are clearly communicated to the person who's the subject of them.
Yes, it still, I think, leaves quite a lot riding on the absence of an inquiry in 2016 as to what was going on, that such old allegations had been referred. But nevertheless, you know, inevitably there's a learning point there, isn't there, given the way that this was addressed by Mr. Justice Warby. Should we move on to the point about how the merits of the Rule 4.5 challenge were then addressed by the judge?
Yes, so we can then see the way that the judge describes an allegation, and there's a small amount of case law on this interesting point of what is an allegation, because I think all of the exactly, yeah, exactly. All of the various regulators have this concept of an allegation, and pretty much in slightly different terms. All of their legislation says an allegation is an allegation that the practitioner's fitness to practice is impaired. And then a question arises, well, does that mean that that is simply one allegation that encompasses absolutely everything which is said about the doctor? Or if not, how should you sort of break it up? And in this context, Mr. Justice Warby, I think, has provided a fairly helpful view on that at 83, that the context, at least this context, points to an allegation being something less formal than a charge. So it need not actually be distilled in the way that it finally is before the tribunal, but it must nonetheless be something that identifies a discrete, specific item of behaviour that's capable of being tied to a point in time, else the rule could not be applied. And then we see further down that the judge put some weight on the fact that the GMC's own internal CBL system had sort of categorised the complaint into a series of, you know, what I loosely describe allegations. And he says that allegations A to C related to 2009, alleged a failure to provide appropriate advice, offer financial incentives, and perform the procedure competently. And then allegation D was the 2010 scan. Then in terms of his more general comments, the judge says there may be cases in which it's not easy to tease out and separate individual allegations from the mass of criticism, but they were in substance, in this case, separate allegations. Now, I think that must be right in terms of you have a scan a year later, which is looking at the allegation is that effectively that showed a problem and the doctor didn't communicate that problem to the patient. Now, it seems to me that is discrete from the way the procedure was undertaken. So I don't find the finding surprising on its facts, but we can see a little bit further down, the judge then cites, this is from the GMC's aid memoir, and the aid memoir suggests that occasionally, but not often, a single complaint document contains more than one distinct allegation, and that the registrar needs to be aware of this possibility and to pinpoint the allegations. And the judge then says that this task was carried out by the author of the allegation information. So the author, the GMC employee who put these things on CBL. And I think it's interesting for the GMC to think about, and indeed for other regulators who do something similar, because I suspect that the GMC are not necessarily intending, when they provide for internal purposes this summary of the allegations, you know, I use the allegate term loosely there, in CBL, necessarily to be saying, each one is something separate and distinct, to which a separate and distinct Rule 4.5 decision should be taken. So perhaps just something to be a bit wary of there for regulators.
It may not matter in concrete terms if all the allegations refer to the same point in time, because then you're applying the same exercise to each of them. But the one that sort of worries me a bit is the case where you have a very broad and maybe diffuse complaint by a patient, or possibly a complaint about one thing. And then there has to be quite a detailed set of investigations carried out by the GMC, which reveals, any other regulator, which reveals more information. And that investigation leads to a crystallization of different points of complaint, which will then have been sort of brought to the GMC's attention, arguably at a different point in time. So, you know, where do you stand there in this question of whether there's sort of one rather general complaint or allegation, or are we talking about separate allegations, each distinct, potentially having come to the regulator's attention at different points in time as a result of their investigation? And I think that one might be quite thorny in a few cases, depending very much on the facts. But I'm sure we all have experience of cases in which the initial complaint looks like one thing, but by the time it's gone through the sort of initial investigation stages, it's looking quite distinct or having different dimensions. So yes, I think probably less consistent with the aide memoire, I'd have thought, than the judge himself commented, really. I think for sort of takeaway point in a way is really that you have to add this case to the list of those cases on Rule 4.5. There aren't a huge number of them, but each one of them is important if you're looking to challenge a Rule 4.5 decision, or of course to uphold one. Pete, again, just looking at the time, I'm going to just check any questions, see if we've missed anything, but I don't think we have. Anyone does want to ask a question, speak now or type now, because we'll probably sign off in a moment, because I think the only other point that emerged from the decision that we just thought we ought to mention was obviously the final point that was made, which was that the judge said that the legal advice was wrong to pin the Rule 4.5 decision to the conversation, the police conversation in 2014, because that was just a sort of very general conversation which didn't really give rise to any facts that called Dr. Dutta's fitness to practice into question. So actually it was 2015 with the CQC referral and the subsequent investigation from which the sort of time for Rule 4.5 purposes began to run. So that was another grounds on which the decision was quashed.
Yeah, I mean, I think that for me was very much an issue of fact, and given that the test under Rule 4.5 in terms of you know, when the matter first comes to the attention of the GMC, that I don't think that has to take a particular format, if you like, but clearly something more than a very oblique discussion that doesn't even directly raise the allegations is required.
There is a final question that's come in, probably more thorny one that we have time to give justice to, but it's an interesting one. Does the regulatory body have the conviction, or perhaps would be able to overrule civil jurisdiction legal hearings where the basis of the documentary evidence outweighs oral evidence? Given this case, the regulatory body should not. Now, there's quite a lot of different scenarios, I think, comprehended in that question, but it is a situation, isn't it, sometimes where there's been a previous civil judgment, which then is taken into account in the regulatory proceedings. And I'm not sure that I would want to say anything more at this in this forum at this point than to say that I think this rule about considering all the sources of evidence in the round is a good one. And you know, that means a very careful analysis of what it is that the different judgments are based upon, the differences between the two, the sources of evidence. That's of course also dealing with a case in which, you know, you're free to depart from previous decisions. I mean, clearly if you're dealing with something like a conviction, there are very specific rules about why the conviction is determinative, and that's obviously a different scenario.
I think the only other thing to perhaps note in terms of the way that the question is framed, without, I don't think we can give a sort of comprehensive answer in the time, but it is that I don't think that a civil judgment is the same thing as a contemporaneous document, and I think they would be treated differently, although the civil judgment is something that can potentially be taken into account.
And then finally, what if the patient is asked to sign a medical record to show agreement or that it's a correct basis of discussion? Well, that's a complex one, isn't it? But I mean, it's interesting that the question of documentary records, we talked about earlier whether or not we were privileging documentary records. I think, to be fair, it's worth remarking that documentary record keeping cuts both ways, because one of the primary reasons why Dr. Dutta fell on the other charges, the 2015 charges, which were not struck down, because of poor record keeping. So he didn't actually keep very good records of his consent process, and that left the door wide open for the unfavourable findings about his process, his taking of consent, and favourable findings for the process of the credibility of the patients on that front. So, you know, I know that doctors are often given the advice that they need to be careful about record keeping. This case certainly reinforces that. Asking patients to sign medical records, I mean, I think there's probably a plethora of guidance on that which we shouldn't sort of tread. I mean, personally, the idea of putting patients under pressure to agree some sort of record of their discussion in the context of a normal consultation is probably not a very attractive one, I suspect, just from a practical point of view. On the other hand, you know, if you are in a situation in which a patient has signed to say that something X is correct, and of course, you know, patients do sign on the dotted line on consent discussions, that is another factor to be taken into account, isn't it? If you're looking at the record of a consenting process and risks are set out and the patient signs to say that he or she has scrutinized and understood this, then, you know, you're going to have to put that into the mix, aren't you, in your factual finding? Well, that is a galloping discussion of some really quite knotty issues, I think. Pete, do you think, having now done the usual thing with council's time estimates, i.e. considerably overrun, we should stop talking about this and let those who are still with us, a very creditable number of participants, go? Yeah,
no, I think we probably should, but no, I think it's been a good discussion, and I hope the people listening have found it useful.
Well, I, for my part, have really enjoyed it, but I've also been much assisted and really stimulated by the questions that have come in. So thank you all for listening and also for participating in that way. So I think we'll say goodbye.
Thank you. Goodbye.
All right. Bye then.